I am very glad to be here in Jurmala. Thank you for invitation. I am very glad to talk to you on a general court case law as well as ECJ case law. I will scroll forward quickly. This is the plan for my presentation. I have chosen to speak on some case laws, decisions from General Court and ACJ. Some of those are already available in Latvian, except of some. Although not all these cases are available in Latvian, but litigation in both ACJ and General Court can be in any language, and the applicant can choose the language for submission a complaint. I'm in the board of AI, and we have great ambitions to make all the judgments in the nearest future, to have all the judgments in all languages in the nearest future. But I'm not going to talk about that. But I hope that will be true. Now about general competencies. Before I talk on specific things, I would like just to remind you the partition of competencies between ECJ and General Court, as well as I will look at some statistic data. General Court can appeal EU IPO, appeal board's decisions. And this is the question of terminology. It can be legally called as cassation court, although it's usually referred to appeal court. And I will use the word appeal, not cassation. If you will look for these documents, you will be able to find by the judgments. That's why General Court's cases are dealing with regulations 2017-1001 on the trademark, as well as regulation number 6 from 2002 on design application concerning WIPO competencies, primary design and trademark register maintenance. I will have a sip of water, thank you. But ECJ, in ECJ, one can challenge the decision of General Court, but there is an appeal filter that I will talk about later. Also, member state courts can ask preliminary questions not only on design issues, but also on Directive 2015-2436, thus making uniform legislation concerning Directive 98/71 on application of design. Thus, I can say that ECJ's competencies are more broader, but General Court is dealing with more in-depth questions. I have also to stress differences between the numbers of cases dealt with each and every one of those courts. That's why I would like to say that regulation of design and regulation are reviewed at the moment, and other speakers will talk about these issues later. Now on statistics. Looking at numbers, I have to conclude that these statistical indicators are quite constant. Every year in General Court there are around 300 applications submitted in the area of design and trademarks. This year it is 147, except for 2023, where there were great number of cases dealt with. Concerning the cases, these numbers are quite similar. 291 in 22, 278 in 2023, and 145 in the first 7 months of this year. Regarding appeals submitted to ECJ on decisions of General Court, this number is varying between 15 and 20%. It is interesting to remark that the number has not changed since the appeal filter was established. That is interesting. Regarding ECJ, since last year's September, it has announced 6 decisions, 6 case laws, 3 preliminary rulings, and 3 rulings on appeals on challenging the decisions of general courts. In the majority of cases, the appeal is denied, or so-called filter for appeal is applied. So now about the appeal or challenge filter. Again, the terminology might be used cassation. From 2019, 1st of May, these challenges or appeals on decisions of general courts or agency or bureau decisions, including WIPO decisions, are dealt with only when the court declares admissibility of those appeals. The appeal should also contain explanation why this question is important for consistency or development or unity of EU law. And only after this admissibility test, the application is being sent to the other party. I will talk about these 3 cases that have been published this year, and they, with them, the challenge was satisfied. One against Jager Wickman on design, then Bonnembo WIPO concerning responsibility of parties, as well as independence of legal representatives, and WIPO, European Foods, concerning the rights of claimant to come up with a claim. And I have chosen these case laws, but I will not talk about them in greater detail. Speaking about preliminary rulings, speaking about trademarks, concerning preliminary rulings, all 3 cases that I have chosen concern limitations of trademarks as well as exemptions of trademarks. I will talk about an Audi case right now on the application of the trademark on radiator board. This was submitted by District Court of Germany. In the general ruling, the Audi or the car manufacturer contested a private person using online site for selling spare parts of the car. So the merchant offered last year to adopt specific radiator board, including an Audi emblem that has been registered as a trademark, and its attachment to the radiator. And Audi turned to the court for the court to forbid this private person to sell these spare parts that corresponded partially or fully to Audi trademark. For you to understand it better, I included a picture which might not be an exact copy of National General Court believed that it has to find out whether Audi's trademark that has a good reputation in Warsaw and in Poland, that the amount of protection concerns also separate elements for attachment of the emblem to the radiator that are identical to Audi trademark, and they could be perceived as Audi trademarks. Member state court said that trademark rights, contrary to design rights, do not contain correction derogation that is being used for the purpose of correction in order to come up to the original trademark or design. The member state court looked at regulation 2017 and saw that there are no measure for correction. Article 9.2 as well as Article 3A to C should be interpreted that the third person who without the manufacturer and the owner of EU trademarks permission imports and offers to sell spare parts, such spare parts as radiator, thus jeopardizing the functions of this particular trademark. First, the EU court said that in this regulation there is no correction measure existing in design regulation, and mentioned a case law C 414 paragraph 28. According to the court, it is not possible to apply this correction derogation without crippling competition between producers of car and sellers of non-original spare parts. Second, ECJ said that Regulation 2017-1001, Article 9, 2AB, the EU trademark owner can forbid third parties to use identical or similar brand only in cases when the functions of the trademark can be jeopardized, including quality or communication or advertisement functions. But the same regulation, Article 9.2c, allows for the purpose of reputation, to forbid the usage of trademark if the gain is gained by a third person. Also, in this substance, and using Regulation 2017-93 ABC, saying that whilst the trademark is not attached to the spare part, then the spare part can be sold, but when the trademark is attached for the majority of the society, it is related to the owner of the trademark, thus jeopardizing the rights and reputation of the trademark owner. Also, it decided that the functions of the trademark can be jeopardized, but it also indicated that a member state court should evaluate whether the respondent's spare parts are identical to spare parts sold by Audi, or those spare parts where the trademark is attached with the permission of Audi. Thus, the court allows the member state's court to decide one way or the other by asking a question whether the third person who, without the confirmation of trademark owner, imports spare parts, namely these radiators, including the element of an emblem or a trademark that is similar to the mentioned trademark, uses it in its commercial activity, thus jeopardizing functions of one or several functions of the trademark owner. But it should be evaluated by the national court. National court's decision differs from Laila Medina's Advocate General's decision, who believed that the silhouette of a trademark, which is a part of the original radiator, the precise replica with a technical aim to attach the emblem of the producer, it should not be considered a trademark. Thus, the trademark has not been used for the purposes of beneficial commercial activities. Thus, in the understanding of Regulation 2017-1001, Article 9, 2, and 3. Also, ECJ evaluated one more issue of a member state concerning Regulation 2017-1001, Article 14, 1c. Interpretation of this article from this, we can understand that the EU trademark's owner cannot forbid a third person to use this trademark for its commercial activity in order to indicate services or goods as such pertaining to this owner of trademarks, especially if the above-mentioned trademark is necessary for indications of goods, especially spare parts. Thus, the question is whether this this article can be interpreted that the owner can forbid a third person to use this trademark or identical trademark to be placed on spare parts, and whether it's technically possible to attach the emblem to the radiator without using the exact trademark. ECJ, already based on its own case law, reminds that a third person's usage of a trademark in order to identify services or goods pertaining to the owner of the trademark, if this usage is necessary, to define the purpose for usage of the trademark cannot be forbidden by the owner of the trademark. However, the limitation should be applied only if the usage of trademark by a third person has occurred with just commercial practice. Concerning this specific case, ECJ indicated that it should be separated. The issue dealt with in the case where where on the spare part a similar trademark is attached, whereas non-attachment of the trademark to the spare part can be used. The identical or a similar application of a trademark to the goods belonging to or sold by a third person exceeds the indications dealt with by the Regulation 2017-101, Article 14(1)(c). According to the Code, thus, it is the circumstances whether the emblem can technically be attached to the radiator without resembling the above-mentioned trademark. The next judgment concerns a similar issue and concerns interpretation of directive of a directive C. And the Buongiorno is a company giving information or services of information using network or mobile connections. It allowed also for a draw with a prize of 1,000 euros from Zara. By opening this website, the person saw a Zara logotype. Zara owner contested Buongiorno concerning his trademark, and also the benefit of Buongiorno gained by the trademark, as well as crippling the reputation of Zara. However, the respondent said that it used Zara not as a trademark, but as a giver of the prize, which is in line with Spanish law as well as with the directive of drawing prizes, and they question to answer for the Spanish Supreme Court whether the Directive 2008/95 Article 6(1)(c) should be interpreted in the following way, that it concerns usage of any type of a trademark for commercial activity performed by a third person according to good practice to identify goods or services belonging to the owner of the above-mentioned trademark, or only such usage of a trademark necessary to indicate the goods traded or belonging to the third person. The question asked by the member state was on this connection between several directives. According to the Directive 2015/2436, Article 14, paragraph 1c, the owner of the trademark cannot or does not have the rights to use in its commercial activity a trademark in order to identify or indicate services or goods as such belonging to the owner of the trademark, especially if the usage of the trademark is needed in order to indicate the goal of services or goods, especially concerning spare parts. But the earlier Directive 89, 104 and 2008/95, Article 6, the interpretation was more narrow. Namely, the trademark could be used only to indicate the owner of the trademark with a condition that it goes hand in hand with just commercial practice. ECJ stated that Directive 2008/95 6(1)(c) is narrower than 2015/2436 Article 14(1)(c) usage that could be forbidden according to the previous legal act, which is at the moment contradictory to the usage, current usage, that the owner cannot contest. ECJ has already stated that although the application of the directive cannot be applied only in situations when the trademark is used in order to indicate to which the trademark belongs, especially concerning articles and spare parts, but these indications should be limited to the goals of the directive. Thus, the 2008/95 Article 6(1)(c) concerns trademarks used by third persons in order to indicate goods and services and its belongings to the trademark owners only in cases when it is necessary that the services and goods belonging to the owner are used for certain purposes. However, the Directive 2015/2436 Article 14 in 1c, in this context, the situation corresponds only to one of all those cases when the usage of the trademark by the owner cannot be forbidden, which also reconfirms the more narrower application. The member state court should be evaluate whether the Buongiorno has used Zara using the Directive 2008/95 Article 5 and whether it was necessary in order to indicate the service that Buongiorno offers, and whether this usage took place taking into account best just practice of commercial activities. Spanish Supreme Court decided on favor of the trademark owner, claiming that Buongiorno used illegal activities using Zara.
In the next case is also a preliminary ruling case. The question was asked by Warsaw District Court, and it related to the exhaustion of rights granted to specific goods. Here, Hewlett-Packard owned exclusive rights to EU graphical and word trademarks HP, and all goods with this trademark are sold via authorized representatives who undertook not to sell these goods except for end users unless they are not in their distribution networks. Also, these authorized representatives have to purchase these goods from other authorized representatives or Hewlett-Packard itself. The respondent in the primary case, Senetic, is a company that distributes computers and computer equipment in Poland, and it imported goods with the respective trademarks in Poland, and they were bought from sellers that are registered in the EEA but are not official distributors of HP. In addition, we should note that the respondent unsuccessfully asked the authorized representatives of HP that these goods can be sold in EEA without violating the exclusive rights of HP. When the case was brought, the Hewlett-Packard asked to stop violating this trademark and also to prohibit Senetic to import, export, advertise, and store for the above purposes all goods with the respective trademarks, which the respondent had not released into the EEA market, or which have not been released into the EEA market with an approval from the Hewlett-Packard. The respondent relied on the exhaustion of such rights, claiming that the Hewlett-Packard released these goods into the market itself or with its consent. From the description, we can conclude that the Hewlett-Packard used a selective distribution system where goods with these trademarks did not include any labeling that would allow third parties to identify markets where they are to be sold. And the owner also refused to provide this information to third parties. And also they are not interested in disclosing their supply sources. The referring court wanted to find out whether Article 13.1 of Regulation 207/2009 and Article 15.1 of 2017/101, if read in conjunction with the TFEU, Articles 36 and 34 of TFEU would allow, considering these circumstances, when the goods are not marked, whether the respondent would still bear the responsibility if such rights were exhausted. Here the EU court reminded that the owner of trademark in the EU has exclusive rights, and it has the right to ban all third parties from importing its goods or release them into the market or accumulate supplies of these goods without the authorization of the holder. Also, it was indicated that Article 13.1 of 2007/2009 includes an exemption, namely that the rights have been exhausted if the owner has released such goods into the EU or EEA market, or if it has been done with its agreement. Here the court has underlined that the purpose of this clause is to align the interests to protect the trademarks on the one hand, and also to support the free circulation of goods in the EU and EEA market on the other side. Moreover, the rights granted by the trademark can be considered exhausted only with regards to the specimens of specific goods that are released into the EU or EEA market, if the owners have so agreed, while the marked goods and their release into the market beyond the EU or EEA does not exhaust the right of the owner of trademark to object against the import and release of such goods into the EU or EEA market without its agreement. Also, the court reminded that, judging by the previous case law, it can be derived that the EU rights are in principle aligned with the national norms, according to which the exhaustion of such rights is a means of defense. Thus, the evidence should be provided by the respondent who claims such rights. Thus, due to the requirements pertaining to the protection of such rights, this proof of evidence maybe should be adjusted. Considering the circumstances of the case described by the referring court, the EU court divided the proof of evidence duty between both parties. And the court also indicated that national courts should adjust this proof of evidence with regards to the exhaustion of trademark rights granted by the EU trademarks. First, the parties, namely the owner of the trademark, should prove that it has itself or has allowed to release the specimens of goods beyond the EU or EEA. If such proof is provided, then the respondent should prove his stance that, namely, these specimens were later imported into the EEA by the owner of the trademark or with its consent. And now about the rulings of the General Court what concerns trademarks. At first, I will speak about a case BB Services EU IPO, Lego Juris, namely Lego pieces with a head shape. In this case, Lego had registered the following three-dimensional trademark with a Lego shape, and it pertained to decorative magnets, computer games, various data media, clothing, hats and similar, including and also games and similar. BB Services brought a claim on recognizing this trademark void and claimed various grounds. For example, Article 7.1ai and II of Regulation 2017/1001. Here we should note that the trademark application was submitted in 1996, and thus the applicable regulation was 40/94. Article 7.1a paragraphs I and II, and according to these sub-paragraphs, trademarks should not include designations that consist only of the shape that depend on the characteristics of the goods, and second, on the shape of goods that is required to guarantee the technical result. Thus, EUPO and its technical body denied this submission as inadmissible. The General Court considered both of the avoidance grounds. First, what concerns the characteristics of the goods, the General Court indicated that this ground cannot be applied if there is at least one major characteristic that is not dependent on the nature of the goods. This allows to conclude that the challenged trademark does not consist only of the shape that depends on the nature of the goods. And what concerns the nature, the court established that this particular good has dual character, dual nature. First, as a figurine used for games that looks like a human body, as this was considered by the appeal body, and also as a joinable human figurine that is characterized by connectivity and modularity in the overall constructor system. So there are two purposes. First, to play with these figurines, which is non-technical, and second would be joinability, which is a technical characteristic because this figurine can be joined with other parts. And also the court established the major characteristics, essential characteristics, and established that the appeal body has not identified several of those technical characteristics. For example, this protruding part on the head, the hook on the hands, and the hole under the feet and at the back of the legs, because this would characterize the joinable nature of this figurine, and this is a major characteristic that is important what concerns its compatibility and ability to be used in conjunction with other goods. Basically, whether this figurine can be joined with other elements of the Lego constructor. Finally, irrespective of the errors made by the appeal body, the court still admitted that Article 7.1.e, I and II are not applicable because several of these characteristics can be changed and configured with a very extensive design freedom. The court indicated that cylindrical form is not characteristic trait of figurines used for plays, and also it's not linked to the general function. And the same applies to the short and square neck and the cone-shaped torso, and also the particular shape of hands and legs and feet. And also the characteristics of this A figurine is just one of the functions that these figurines can have. This is just one manifestation of this function. And the General Code had a similar approach with regards to Article 7.1.AII. It indicated though connectivity and modularity is achieved due to the significant characteristics. Still, there are other significant characteristics that are not needed to achieve this technical goal. The court also added that the challenge trademark does not prevent the competitors from releasing into the market similar toys with similar characteristics, and does not prevent the competitors from distributing figurines of different designs that would be compatible with the Lego system. And there is an extensive design freedom what concerns these figurines. I don't know if I have overused my time because I was slightly late starting, but maybe I can, if I have overused my time, then maybe I can just leave these slides for you to read, because my presentation will be available, and I'm always happy to answer your questions and to discuss these issues with you. And I will also have a second presentation on the language factor in